Hi, welcome to Commercial Law Tutorials. So, what are the essentials of a valid contract? The first one is there should be agreement. Then the second one is legality. Next, contractual capacity. Then necessary formalities should be upheld. Next, performance must be possible. And then there should be serious intention to contract. And lastly, agreement must not be vague. Now, agreement must be lawful. That is our next essential. A valid contract cannot come into existence if the agreement is unlawful because it is prohibited by state law. The legislative laws expressly or impliedly forbid the contracts. The prohibition referring to either the form of the contract or performance to be made in that contract. If the contract is prohibited by statute, that contract is unlawful and is void. These prohibitions can be expressed or implied. Implied prohibitions arises where a statute, without expressly prohibiting an act, provides a penalty for the performance of the act, and the imposition of the penalty is not simply a fiscal provision for the benefit of the revenue for the state, but it is to forbid that act. The examples of contracts which are forbidden by statute are the sale of certain goods like drugs and wild animals, an agreement to work for a wage less than the minimum provided by industrial legislation, a sale of goods by gross mass, agreements made for illegal activities which may include human trafficking. Then, a contract can be also unlawful if it is prohibited by common law. Agreements that are regarded as contrary to public policy or contrary to acceptable standards of morality are void. An agreement is contrary to public policy if it is opposed to the interest of the state, justice, or the public in general. The following contracts are rendered illegal at common law. An agreement by a party to pay his advocate or attorney a fee only if he has been successful in the action, or to pay a witness lots of money. Agreements in unreasonable restraints of trade, that is, contracts which aim to restrain a person from exercising any lawful business in his own way. Then unreasonable employment agreements and also price-fixing agreements. We have agreements interfering with justice, that is, agreements to commit crime or delict. Then agreements to procure marriage for reward, they are also not valid. Agreements encouraging sexual immorality, they are also illegal under common law. Now let us look at various cases I have just picked which explain some of the examples of contracts that are not allowed by common law. The first case is the agreement to terminate a marriage or consideration of terminating a marriage. In the case I have here, Harris, a married man, was sued by Friedman, a spinster, for damages for seduction. Friedman agreed to pay Harris $800 for divorcing his wife and marrying her. Harris did not divorce his wife. The agreement was held to be void because agreements to terminate marriages, they are void. The second case is agreements to procure marriage for reward. In the case I have here, Taylor promised to pay Woods if he introduced a suitable suitor to Taylor's daughter, and a marriage should result from in that introduction. The agreement was one of marriage brokerage and against public policy, and it was held to be therefore unenforceable. It was just void. The third case I have for you is where a covenant was entered into between a clothing company and mason who was employed in one of the company's branches. He was restrained from taking employment with any person carrying on a similar business within 25 miles of London for 3 years. It was held that the restraint was unreasonably wide, therefore void. It was really too much. Then the fourth and the last case is where Brown and Camban agreed to lend an insolvent person 800 on condition that he should bond certain assets as security. It was an offense under Insolvency Act for an insolvent to obtain credit exceeding 25 without giving written notice. The insolvent executed and registered the bond and ceded it to Findlay, who sued Brown and Camban for the amount of the loan. It was held that both the agreement and the bond were illegal, null and void. Those were the cases I had for you. Next, I will look at the terms which govern cases involving illegality. We have ex turpi causa. This means no action arises from a base cause. An unlawful agreement which has not yet been performed either in whole or in part will never be enforceable under law. The general rule is that if the contract is illegal, it is unenforceable, and the law cannot give effect to any illegal contract. The ex turpi causa rule is absolute in its application and has no exceptions, which means strictly by no chance, under what circumstances, rain or sunshine, an illegal contract is definitely unenforceable. That is ex turpi causa rule. The ex turpi causa rule was applied in this case where Kennedy sued Steen for 200 on a promissory note. Steen admitted signing the note but contended that he and Kennedy had unlawfully bought diamonds from a police trap for $400, which amount had been confiscated by police. Thereafter, Steen agreed to pay Kennedy 200, being portion of that 400. Steen had not yet paid that 200 to Kennedy. It was held that the note arose out of transactions which were, to Kennedy's knowledge, illegal and void, and his claims was accordingly unenforceable. Court will not come to the assistance of a person who has entered into an illegal contract for the purpose of enforcing the contract. Now, the other term which is also used in illegal cases is the in pari delicto rule or par delictum rule. This means loss lies where it falls. If you enter into a legal contract and you acquire losses, they are your losses. You have nowhere to complain or no one to tell about your losses. This rule is not absolute. It has exceptions. The exceptions are fraud, misrepresentation, and unjust enrichment. The general rule is that a party cannot recover money or property in the pursuance of an illegal contract. Courts cannot be used as instruments to perpetuate illegality. Where the parties are equally guilty, the person who is in possession will prevail in that. Where money had been paid or property delivered to an illegal contract, loss lies where it falls. The policy of this rule is to discourage illegality and immorality. Note that the courts do not apply the par delictum rule where only one of the parties is in delicto, that is guilty, or where one is clearly less in delicto than the other. Ratification is granted. We'll look at two cases, The first one is where strict application of the rule of pari delicto rule is seen. The case of Judge Bay versus Kasim. Judge Bay, the registered holder of a stand license, entitling him to occupy a stand in Johannesburg, Malay location. Judge Bay sublet the stand to Kasim, which was illegal under the location regulations. Kasim was carrying out all the terms of the lease. Judge Bay just sought to eject Kasim on the grounds that the lease was illegal. It was held that both parties were equally guilty of breaking the law, and the law lied where it falls. Then we will look at the case where the law was relaxed. The facts are that Lebis, an agent, sold to Pada and wanted to deliver 25 cases of condensed milk, which to the knowledge of all the parties had been stolen. In fact, unknown to the parties, the cases contained bricks, not condensed milk. Lebis signed a promissory note in favor of Pada in refund of purchase price. In an action on the note, a magistrate granted absolution from the instance. It was held that on appeal, following Judge Bay versus Kasim, Pada could enforce the note because public police demanded a relaxation of the par delictum rule to prevent Lebis being enriched at the expense of Pada by being allowed to retain money for which no value had been given. The next essential is parties must have full legal capacity to contract.